The responsibility to maintain accurate and complete records is one of the cornerstones of professional real estate brokerage in Arizona. As discussed in the previous sections, licensees must deliver all offers promptly, disclose information properly, and ensure timely submission of documents. However, the duty to safeguard and retain those documents ultimately rests with the designated broker. This responsibility ensures accountability, transparency, and compliance with the Arizona Department of Real Estate's record-keeping requirements outlined in ARS Section 32-2151.01a and Commissioner's Rule R 4-2 8-802. These laws collectively establish that the broker must maintain true copies of all receipts, disbursements, contracts, closing statements, and any related transaction documents for at least 5 years from the date of execution or closing, whichever occurs later. This section ties directly to the earlier lesson on the timely submission and delivery of offers and documents. Once an agent provides copies to all parties, those documents must also be submitted to the broker for proper filing and review. The broker's obligation does not end at merely collecting them. It extends to organizing, verifying, and safeguarding the records in a way that ensures accuracy and accessibility for audits, investigations, or client inquiries. Record retention is not just a technicality. It is a legal safeguard that protects both the public and the brokerage from allegations of misconduct or mishandling of client funds. Under ARS Section 32-2151.01a, the designated broker must keep complete transaction files that include all contracts, correspondence, addenda, offers, counteroffers, escrow closing statements, and any receipts or records of monies received or disbursed. These records must be stored in the broker's Arizona business location, accessible for inspection by ADRE at any reasonable time. If the broker maintains electronic records, they must be secure, backed up, and easily retrievable for review or printing upon request. The rule applies equally to all transaction types: residential, commercial, property management, and leasing. A common example of this obligation in practice involves earnest money deposits and trust accounts. When a broker or salesperson receives earnest money from a buyer, a receipt must be issued immediately, and the funds must be deposited within the required time frame into the broker's trust account or the designated escrow account. The broker must maintain true copies of all receipts and disbursements, showing when and where the funds were deposited, to whom they were disbursed, and for what purpose. For property management brokers, this extends to rent collections, security deposits, and owner disbursements, as specified in ARS Section 32-2175. Any discrepancy or missing documentation can trigger an ADRE audit or disciplinary action under ARS Section 32-2153A3 for negligence or failure to exercise supervision. One of the most common record-keeping violations occurs when a salesperson fails to turn in documentation promptly, leaving the broker unaware of critical details about the transaction. To prevent this, R 4-28-1103A requires designated brokers to establish written policies and procedures ensuring timely submission of all transaction files. Brokers must verify that each file includes fully executed agreements, disclosure forms, escrow closing statements, and any receipts for funds exchanged during the transaction. ADRE investigators regularly audit these records during routine compliance checks, making accuracy and organization essential to maintaining a clean licensing record. For example, if a listing agent collects earnest money and gives it to title but fails to obtain a receipt or confirm deposit, and later the buyer claims the funds were never received, the broker could be held liable for inadequate supervision and documentation. Similarly, if a property management broker disperses rent funds without retaining proof of payment, or a corresponding owner statement, the broker risks disciplinary action and potential restitution. The law expects every financial transaction within the brokerage to be traceable, transparent, and verifiable through documented evidence. The case of Arizona Department of Real Estate versus Realty Executives, 2010, emphasized that brokers are the custodians of their firm's records and bear ultimate responsibility for their maintenance, even if individual agents mishandle or lose documentation. The ADRE reiterated that failure to maintain true copies of escrow statements, disbursement receipts, or client communications constitutes a serious breach of fiduciary and supervisory duties. Today's digital environment has simplified record keeping, but not reduced its importance. Brokers are encouraged to use secure transaction management systems such as SkySlope, BrokerMint, or Dotloop to store documents electronically. However, these systems must meet ADRE's requirements for accessibility and security, and all records must be downloadable and printable on demand. Brokers should also back up digital records regularly and restrict access to authorized personnel to ensure confidentiality and compliance with R4-28-802B. To maintain compliance, best practices for brokers include creating a comprehensive transaction checklist for agents, performing regular internal audits of files, and documenting all deposits and disbursements immediately. When funds are held in escrow, the broker must retain copies of all escrow closing statements provided by title companies, showing that the transaction was completed properly and funds were distributed as agreed. Review summary. The designated broker is legally responsible for ensuring that every transaction within the brokerage is documented, traceable, and securely retained for at least 5 years. Under ARS Section 32-2151.01a and R4-28-802 and R4-28-1103, brokers must maintain true copies of all receipts, disbursements, escrow statements, contracts, and related documents. This requirement supports accountability, consumer protection, and ADRE oversight. Proper record retention prevents financial mismanagement, protects against liability, and upholds the credibility of the brokerage. In essence, the broker's file is the complete story of every transaction, and that story must be clear, accurate, and accessible at all times. Discussion prompts. Why does Arizona law require brokers to retain true copies of receipts and disbursements for at least 5 years? Answer: to ensure transparency, accountability, and the ability for ADRA to audit and verify that all funds and documents were properly handled. How do electronic record-keeping systems align with Arizona's record retention requirements? Answer: electronic systems are acceptable if they securely store records, maintain legibility, and allow quick retrieval or printing upon ADRE's request. What are the risks for a broker who fails to maintain accurate records of escrow transactions? Answer: the broker can face disciplinary action under ARS Section 32-2153A3, potential fines, or license suspension for failure to supervise and comply with statutory record-keeping obligations. Closing remarks. A brokerage's integrity depends on its records. Each receipt, closing statement, and contract tells part of a client's story, and it is the broker's duty to preserve that story accurately. By maintaining true copies of every transaction, brokers not only comply with Arizona law, but also protect the interests of clients, the reputation of their firm, and the integrity of the profession as a whole. Proper record keeping is not just about avoiding penalties. It is about ensuring that trust, transparency, and accountability remain at the heart of every real estate transaction.